This is the Mobile Home Park Lawyer Podcast with Ferd Niemann. If you're looking to generate wealth and passive income in the lucrative world of mobile home parks, you're in the right place. You'll discover solutions to the common legal and operational pitfalls and how to optimize parks to maximize income. Your host is in the trenches. He's a real estate attorney, financial analyst, and mobile home park investor and operator. Now, let's turn it over to Ferd Niemann.
Welcome back, Mobile Home Park Nation. Ferd Niemann here again today with another episode of the Mobile Home Park Lawyer Podcast. Today's episode, I'm going to give you a little bit of the highlights on what is a private place memorandum and why you may or may not need one. I've done a number of episodes on syndications, but apparently some of y'all are thick-headed because people regularly come to me and say, I want to raise money, I'm going to have some investors, I'll give them a promote, or I want to promote, I'll give them a pref. Oh, they're just sending me a check, like I'm doing the work, but like, I don't want one of those PPMs. Okay, people don't want PPMs for two main reasons. One, it's complicated, so it's hard for them to understand, which generally hurts their ego, so they don't admit that, especially because they'll be exposed if they try to explain it to investors. But two, it's expensive, right? I mean, it just is. Like, you're not going to get a PPM done for $2,000, right? They go, just give me one of those LLC operating agreements. Maybe we'll just do a joint venture. Like, okay, well, what's a joint venture, right? So we'll get into that, but I mean, just general rule of thumb, if it's me and three other guys and we all are materially actively participating, then maybe we're a joint venture. But if I'm doing all the work and I have all the skill and expertise and the other three guys are brain surgeons, despite being smart guys, they're not really contributing to this cause and they're just cutting me a check and then they're getting specified rate of return or specified preferred equity rate of return or a pref, they're going to be what we call limited partners or Class B members. I'm going to be the general partner, the Class A member, or the manager. That's a syndication. You can call it a banana. It doesn't make it not a syndication. Why is that important? The Securities and Exchange Commission, they regulate syndications. This came out of the SEC Act, which was 1933, I believe. And basically, it said, if you're offering securities, because you think about it, when I'm bringing on investors, I'm not selling them real estate. They're not investing in real estate directly. They're investing money for a membership interest or membership units within an LLC typically. And the LLC owns real estate or one of its subsidiaries owns real estate. So I'm offering a security, okay? And securities are supposed to be regulated. That means, like, if you ever bought like stock in Coca-Cola, you get a prospectus that's warning you about all the scary things that go wrong with Coca-Cola. That's what a private place memorandum is. It's basically the prospectus. But it makes you, if you follow the right rules, it makes you eligible to be exempt from registration. Because Coca-Cola, they can have three guys sitting in the corner who are regulatory guys that just sit there for $100,000 a year each, batting down the SEC. But little old me in one deal, I can't afford that, right? So I just can't raise money. Wait, I can if I do it right. And that's through the private placement memorandum process. The good thing about PPMs is there's no limit on the amount of money you can raise. And you got to structure it right, but you can do them for business or real estate transactions. Today I'm just going to walk through my outline. I actually have notes on this one, quite a bit of notes, because I just taught some other law clerks and paralegals and associate attorneys at the firm little 101 about PPMs, so got some notes ready. I generally know most of this stuff by heart, so I'm going to skip around. But basically, document structure, I'm going to go pretty fast through this because it's kind of boring, to be honest. Lawyering is boring at times. The document structure, and this is going to be different for individuals, but it's going to have things like disclosures or notices, some of which are state specific, a summary of the offering, details on the company, the compensation of the manager and affiliates. Like, I have deals around the syndicator and I have lots of affiliates. Like, the syndicator is FFL LLC for Ferd and Logan LLC. The property management company is Custom Property Management, owned by Ferd. The law firm is the MHP Law Firm, owned by Ferd. The contracting entity, the brand entity, is Third Floor Properties, owned by Ferd. Okay? And you just need to disclose that, right? And I'm very transparent about it, right? Why would I not be? Okay, the capitalization, it's like the capital stack, sources and uses. And there's a bunch of risk factors, like risks in the offering, the structure, the management, real estate risk, financing risk, tax risk. There's a section on financing. There's a section on the summary of property management, the business plan, the distribution plan, transactions with members and managers, litigation. What is the offering price and how does dilution impact it? What are the use of proceeds? Who are the eligible investors? I'll get into that. What are the subscription procedures? Give me a description of the units. Are there limiting or other provisions? What about conflicts of interest? Like, here's a conflict of interest. Ferd also owns other trailer parks. He's not giving 100% of his time in this trailer park. He might own 2 trailer parks in this market. Right? That's a conflict of interest. Like, this is not my only job to be the manager of this one transaction, this one PPM. There's a section on income tax consequences. That's a big deal. Then generally there's a miscellaneous, a glossary, and then there's exhibits. There's quite a few exhibits if you do it right. There's 2 types of offering. There's the 506B and the 506C. The way I remember them is B for buddy. Basically, C is for credit investors only, meaning rich guys. Okay, what's a credit investor? There's a number of subcategories, but basically it's you either have $1 million net worth, not including your home, or you have an income of $200,000 each of the last 2 years with an expectation of the coming year. If you're married, it's $300,000. Okay, so that's generally rich guys, especially considering in 1933 that was a rich guy. Nowadays, the million ain't what it worth used to be, especially in the Biden economy. It's kind of probably more like, $50 at this point. But no, I'm just giving crap. 506B, I say B for buddy because you don't have to be accredited. A lot of my buddies are not rich guys, right? But they can't really be my buddies. It just means they don't have to be accredited. They do have to be sophisticated, and you can limit that to up to 35 people. Sophisticated is a technical term. So if I have someone who is a real estate and corporate and finance lawyer who is top of his class in law school, number 1 in the bar exam, and is in his first year of practicing law at a securities law firm, and he makes $199,000 a year, is he accredited? No, because he has no real net worth, and his income does not qualify in quantity or in years of quantity. So he's not accredited. But is he sophisticated in this particular financial and legal matter or things of this sort? I would argue yes. Let's take a different example. A neurosurgeon. Neurosurgeon is the smartest guy in med school and has a salary of $500,000 a year for his first year in the business. His net worth is negative because he still has tons of student loans. Is he accredited? No. Is he sophisticated? Not likely as it pertains to understanding and evaluating the risks of this investment. It's an odd rule in some respects, but they had to make a rule. It's a little archaic because in theory, the neurosurgeon who makes $500,000 a year for 3 years, but gambles it all away, is accredited and gets in the deal. But the smartest syndication attorney in the country that makes $199,000 for 5 years in a row, or for 50 years in a row, and donates 100% of the money to charity, who has no net worth, that person is not accredited. So they only get in the sophisticated 506B for buddy, but not the 506C. The big difference is, practically, is if you're going to market on the internet, you're automatically a 506C. So if you're doing the buddy route, it's got to be people, basically friends and family, or people you have a pre-existing materially significant relationship with. If you're going to be out there like, invest with Ferd, like, okay, you can't put the toothpaste back in the tube. You're now a 506C, which means you can never let in only sophisticated investors, meaning people who are sophisticated but are not also accredited. Some are both. I would argue that I'm both, because I meet the income threshold, the net worth threshold, and I think I'm relatively sophisticated at this nature, this type of investment. Okay. Key PP, another provision that's key, if you go the 506C route, it's more likely that you verify your investor's accreditation status by using a third-party verification source. It could be some website like Verivest or something. It could be their CPA, their lawyer, their financial advisor that basically vouches for them. Sophisticated, it's not a number game, right? It's a quote, are you sophisticated? So then you're going to need to do a more detailed investor questionnaire asking, basically asking questions about them to ascertain if they are in fact sophisticated. Because you, the syndicator, could have risk. The purpose of the PPM, in my mind, one of the purposes is it protects the syndicator in the event everything else, goes crazy. So let's say the deal you're doing just crashes and burns. It's not really your fault, but it does. Okay, but then it crashes. Let's say the tornado comes in and takes out all the trailers. And you let in your brother. My brothers are smart guys, but they're both teachers, so they don't make $200,000 a year. And I'm pretty sure they're not millionaires. And as it pertains to this type of investment, they're not sophisticated. So I can't really let them in as a 506B because they're not sophisticated or accredited. I can't let them in a 506C. They're not accredited. But let's say I make an exception because they're my brothers, and they happen to have scrounged up $50,000 minimum offering, which they could do, right? They're hard workers. They mow grass in the summers and do stuff. They got $50,000, but I can't put them in my deals. Never have. And if I did, and let's say the deal went south, it's very possible that someone else, likely not my brothers, but likely the neurosurgeon who just lost $500,000, it's likely that guy sues me. And we all know why we use LLCs for protection. Well, the reason we use PPMs for protection, among others, is if all goes poorly, it's another layer of immunity for the syndicator. But if you break the rules, you're in trouble. Part of the original rule, the reason they have these thresholds is the government didn't want ma and pa, not ma and pa park seller, but like ma and pa investor, spending their last $50,000 on a risky investment. So by rule, in theory, private placements, private equity in real estate is risky, whereas Coca-Cola is safe because Coca-Cola is regulated. Okay, Rich Dad Poor Dad has a number of great books. Most of you have read at least Rich Dad Poor Dad. His second book was Cash Flow Quadrant. His third book was Rich Dad's Guide to Investing. I read all of them during my graduate school year when I was 23, and I read them back to back. Boom, boom. I read the first book, super pumped, ready to get my day job. Second book, okay, more detail. Still don't have all the nuts and bolts actually how to do this. Third book, Rich Dad's Guide to Investing. I'm like, oh my gosh, I'm so ready to do this. And then I got to the part about 506C and 506B, and I'm like, oh, I didn't qualify. So like, okay, great. Put this on the shelf. Don't break glass. Come back later. So anyway, that's the key thing here. If you follow the rules, you've got some additional protection if things go poorly on the deal. Okay, what are the key terms? Minimum offering. This is the minimum amount of money you need to raise in order to, quote, launch the deal. And if your investors subscribe, and that's basically the contractual commitment where they say, look, if the minimum investment is $50,000 and that is one unit, so the unit price is $50,000. If John Smith signs a subscription agreement, which is one of the exhibits to the PPM, and says, I subscribe to give you $50,000, it means, but if the minimum offering is $700,000 and the maximum is $1 million, and I only get to $695, there's not a real commitment in the subscription. They can bail. But if I get to $700, that's the minimum, they're in, even if I don't get to the full $1 million. So generally, the minimum is what you really need. The maximum is like, okay, a little extra. Like, I really don't need my developer fee. I'd want it, but like, I'll generally make the delta be at least my commission or my developer fee. And sometimes you get other stuff, CapEx or expansion, that is like maximum. And you have to do, that's the next term is maximum offering. Because if the maximum is $1 million, like what if somebody puts in, for easy math here, 50 into 700,000 is 1/14 of the LP. Okay, well, if I go to $1 million, the same 50,000 only gets me 1/20th. That's not very cool. So what changed? Well, we diluted you. We brought in more people. The GP share doesn't generally get diluted, at least not on a membership unit and a split before the pref. Okay, next key term, what are the project-related costs? These are things like total purchase price, total project costs, which generally include fees, CapEx, reserves, etc. And then what are the debt and equity amounts? Then basically we'll put in there what are the percentages or the ratios associated with the same. Okay, next term here, minimum investment. I already kind of covered that. You can basically say it's $25,000, $50,000. Those are typical, but it's really up to you. Unit price, the price per unit is pretty easy. The next one, the promoters care about this. What's the splits? The GP-LP. It's really not a GP and an LP and an LLC. It's the membership units. It's the manager versus the investor. And you can have series. This gets more complicated. The Series A, Series B. Sometimes you'll give different series based on different amounts. Like I've had deals where if you put in 50,000, you get a different split than you put in 250, then you get $1 million. Some people do it based on first people in. People who sign a debt guarantee, things like that. That'll often be a different fee. Next is the preferred return. The preferred return is basically the percentage interest or percentage return that the limited partners get in advance of the manager getting any promote. And then the hurdles. So common would be like a 8-pref 30-70. That means the investors get 8% return, and then any dollars after that are split pro rata pari passu, 30% to the general partners, 70% to the limited partners. Additional hurdles could be, but up till an internal rate of return of 15%, and then the new hurdle is the GP gets 50 and the LP gets 50. They're kind of new splits after a certain hurdle. Think about the Olympic event, like you hurdle, you jump over something. When you jump over a certain hurdle, the things change, right? I've accomplished this. And then this is often called a waterfall. The priority of water falling down different layers. Other terms that are key, a lot of people don't mess with this, but it's pretty sophisticated and we like to do it occasionally, is you gotta get CPA advice. I'm not a CPA. I am a lawyer, but this is not legal advice. This is public education at no cost to you, which, by the way, I didn't have this available to me when I started doing this, so you're welcome. The next one is depreciation allocation. I got a whole other episodes on cost segregation, bonus depreciation, real estate professional, all that jazz. Should do more on tax. I haven't really got around to that. I'm going to make a note of that, actually. I'm a tax dork, so I should do some episodes on tax stuff. Okay, and the next is what's the member ownership percentages. This often tracks with the GP-LP splits, but the splits are really the distribution of revenue percentages, not really the voting rights percentages or what issues you can vote on. And then what manager restrictions. It's common for the manager to not be able to change the manager's compensation. But other than things like that, rarely do the limited partners have a lot of vote. The next most common would be the LPs need to approve a sale or a refinance, but definitely manager compensation. And then also manager incompetence. You can remove the manager typically for just cause. And they might require supermajority votes for some of those things, not just 51%. Depends on what the splits are. Okay, next, this is what my clients really care about. What are the fees, right? What are the key manager fees? Manager, aka sponsor, promoter, syndicator. Okay, there's an acquisition fee sometimes. There's a disposition fee. There's a refinance fee. There's a debt guarantee fee. There's an asset management fee. There's a property management fee. There are voluminous other fees you can come up with. Pick your poison. Personally, I like to do less fee and higher promote. So I would argue my deals compared to the competition are less fee driven, but I probably get a bigger piece of the pie. But I pitch it to investors as, look, I have to deliver a certain pref to you, then deliver another hurdle before I really make any real money. I'm not feeing you to death. I do charge a property management fee, but I have to hire property management staff, including like basic overhead accounting, not just the manager on site. Okay, the next key term is distributions to members. And you can distribute expenses. Generally it's like expenses get paid first, then reserves, then debt service, then the splits. Then paid out. You got different splits based on operational cash flow, refinance cash flow, sale cash flow, liquidation cash flow. And then you should also a key provision, in my opinion, is the financial model. I tend to put that as Exhibit C, the business plan, with the excerpts from Excel. And I also have a pitch deck. And then what's key amongst this from a narrative is the assumptions. And then structurally, I tend to have an LLC that's a contract LLC or a brand LLC, be buyer LLC in the purchase and sales contract. And then I have investors LLC, and that's where the LPs and the GPs have membership units. And then they are a wholly owned parent of wholly owned subsidiaries, the Homes LLC, which will need its own operating agreement. the land LLC, which will need its own operating agreement. And then sometimes the manager or managers of an LLC. There are some deals where I'm syndicating and I'm the only syndicator. But like my current deals, it's FFL LLC. It's Ferd Logan. Me and my dad and my buddy Logan, who's my CFO and CIO, we're the manager. So we have our own little LLC and we have our own splits in there. And, frankly, it's none of my investors' business if we are 1/3, 1/3, 1/3, or 98, 1 and 1. It just needs the manager's LLC, and then who is the signatory and has an authorizing resolution as the signatory on behalf of the manager, and in this case it might be Ferd. All right. Next part of this, you generally need to get basic data. I have like a 40-question intake form of basic data from the client. And sometimes I am the client, right? But, basically information on the sponsor entity, the syndication entity, the deal, the property, the market, the offering description, the types, the minimums, the maximums, some of the stuff we're talking about here. Generally, this would also be great to have third-party reports as exhibits. A lot of people don't do this. Ugh, it pains me. But if you got a zoning letter, tell your investors. You got all this risk. The PPM, the prospectus, it's basically a sky is falling risk document. But hey, look, I'm trying to also raise money here. It's like there's always risk. Oh, but by the way, I have a clean phase one. Oh, by the way, I have a clean title. Oh, by the way, I have a survey. By the way, here's a zoning letter from the city saying I can do this. Here's development plans. Okay. So that's a key third party. I call it Exhibit F, third party reports. Exhibit A is the operating agreement. This is a very complicated operating agreement that tracks specifically the PPM. You cannot use a regular operating agreement. Then I got Exhibit B, form of subscription agreement. Exhibit C, the business plan, which may include the offering memorandum or the teaser and the cash flow analysis. Exhibit D, the form of new member signature page. That's basically the signature page to the operating agreement saying, look, you're now a member. You must abide by the terms. So I like Exhibit E to be the financing or term sheet to show the investors, like, look, I have a loan commitment or a preliminary loan commitment. Exhibit F, third-party reports. Exhibit G, investor questionnaire. If you want to, this generally is best practice to investigate by questioning and or third-party verification whether or not your investors are what they say they are, sophisticated or accredited. Exhibit H, property management agreement. Exhibit I would be an foreign investor information or notice. If you bring on foreign investors, there's additional rules. There's also rules if you bring on IRAs or foreign money. There's a way to do it through a feeder fund through like the Cayman Islands. I personally have never taken on foreign investor money, so that's not something I'm an expert on. I've done it. I've looked at it and had some people research it on client PPMs. We do have some clients that have PPMs from Israel and other places that regularly take on foreign money, but I've never done it on the syndicator side, so I'm not as sharp on that as I otherwise could be. Okay, post-raise, meaning post-raise SEC filings. This is something people whiff on all the time, I'll be honest. And basically, once you start raising money, you have 15 days to file a notice with the SEC on a Form D. And most states say you have to also file, this is like the blue sky laws, you have to also file with the states. The states charge you a fee on the low end. I think some are even $0, but some of them are expensive, like $1,000. If you have one investor from California, it's $1,000. So you might have to spend $3,000, $4,000, $5,000 on state filing fees. Plus, you got to do this, and it's a very convoluted process. It shouldn't be that hard, but it's super frustrating. Save that for another day. Dealing with the SEC on this process, but it's part of the jam, right? There's other options for raising money, like you can do crowdfunding. Basically, crowdfunding, you can have like lots of little investors. You're only allowed to raise $1,070,000 in a 12-month period. So, honestly, I've never done crowdfunding. I just saw that on the internet. But there's a way to do it. Here's an interesting thing about crowdfunding. Not really crowdfunding, is money finders. These people come out of the woodwork. Whenever I'm talking about syndicating deal, there's one particular group of people who I'm not going to denigrate publicly here, who come out of the woodwork and say, I'd like to take all your equity. I want it all. I'm like, really? Right out of the gate, I'm raising all the money. Yeah, here's how I work. I go get other people. I know a bunch of rich foreign doctors, and these rich foreign doctors are going to put in $50,000 a piece, and I'm going to raise it all in a minute, and here's what I want. Like, what do you want? I thought you wanted the equity. You want to put up the money. Oh, I do, but I want 30% of the GP. It's like, what the hell are you talking about? Well, I'm a money finder. And I'm sitting here like, are you a licensed broker-dealer? No. Well, you're violating the SEC laws, and if I let you do this and pay you 30% GP, we're both going to jail. So, no thank you. This is a big one. You cannot pay people to raise money for you unless they're a licensed broker-dealer. Like Merrill Lynch, I'm sure they're a licensed broker-dealer. They can bring you rich guys, okay? So, a lot of my clients, not even my clients, a lot of people try to do a workaround. Like, well, tell you what, I'll give you 5% of the ownership, but your job is not really to money raise. You also need to, like, I don't know, approve the budget or go do some due diligence. Make sure you get in a picture. Things like that. And they come a co-promoter. People do this all the time. I don't agree with it. And they just say, no, it's a co-promoter. They're materially and actively participating. And then it's like an issuer exemption. I think the workaround scenario should be highly scrutinized. But people do it all the time. They want to just say, oh, I raise money. And it's just middlemen on top of middlemen. And it's a big no-no under the SEC. So don't do it, in my opinion. Now, that's the main blocking tactic. Let me see what else I got here. I got an org chart. I can't really describe that. Well, I can, but I'm not going to because you got to pay for that. Information needed to prepare PPM. I mostly covered that on the GP, the fund syndication, the property, the market, the offering description, etc. So there's lots of good stuff here that you need to, work through, so to speak, as part of PPM. But just going back to just the beginning, a lot of people say, I'm just going to do a joint venture. What does a joint venture mean, right? If it's like my dad and myself, like the two of us, we did joint ventures. Hey, Dad, you're going to do construction management and property management and source homes. You're going to work on it, okay? And you're going to put in 50% of the money. Okay, what I'm going to do is financial analysis, legal analysis, and due diligence, and collaborate on budget and operation. And I'm going to put in 50% of the money. That's a joint venture. If we say, hey, here's the deal. We're going to do all that on the next deal. We're going to get 5 surgeons who have a lot of money, who are rich guys, and they're going to send us $100,000 each. We're going to pay them an 8 pref and give them 70% of the cash flow after the 8 pref. That's not a joint venture. That is a syndication. If you're doing a syndication, you can call it banana. I don't care. It's a syndication. You need to do a PPM or you might go to jail. And this is not like jaywalking. Okay? You jaywalk like you speed, like confession here, I speed. I don't speed crazy. I drive for safety, but also efficiency. So I don't drive 25 over limit, but I might drive 7 over on a regular basis. If I get pulled over, I will pay the piper, and I will admit that I drove 7 over, and I will have to pay my ticket. And hopefully, as being a lawyer, I'll get some professional courtesy, and maybe they'll give me a discount or something. But I am willing to take the risk because I get everywhere I go 7 miles an hour faster, and the risk of getting caught and getting penalized is not that great. Okay, this is not 7 over. If you jack with the PPM rules and then you get caught, it's like going 100 over, and you go to jail. There's a bunch of guys in black suits that come after people. So be smart. This is the blocking and tackling of a PPM. Until next time, thanks and God bless.
You've been listening to the Mobile Home Park Lawyer Podcast with Ferd Niemann. Ready to learn more? Go to www.themobilehomelawyer.com for free resources and materials to help you succeed. If you love the podcast, go to Apple Podcasts, give us your review, and subscribe today. Thank you for listening. Neither the Supreme Court of Missouri nor the Missouri Bar reviews nor approves certifying organizations or specialist designations. The choice of a lawyer is an important decision and should not be based solely upon advertisements.